Ready when you are.
Yes, Conferences, I just want to start here really by almost apologizing that to be here with such a matter, which is a waste of the court's time. Really. And that's why in our heads we say that it's unfortunate and embarrassing that this court has to convene on an urgent basis for matters coming from baseless, unsubstantiated, and false so-called evidence, and at best an abuse of the court process. And I will address that when I talk about costs at the end. But essentially, what we are here for is a concoction of demonstrable lies by Mr. Khumalo, made-up stories, defamation of character of, in particular, former President Zuma, Ms. Zuma Sambudla, and the people who used to be in the interim leadership corps, national leadership corps with him. And we will show this court blow by blow where those untruths are. And we will submit that even with the half an hour of evidence from the bar that we received this morning, and my learned friend was saying I should object. Well, there's nothing to object to, because if he didn't give evidence from the bar, he would have nothing to say. He was now turning into a handwriting expert, and look at this comma and that comma there, and even taking instructions from his junior for more evidence from the bar. Now, the issues in this matter are quite simple on the merits. The first issue is the alleged basis of this application, which is the doctrine of ultra-vires. So if you look at paragraph 2, or prayer 2, it says the first respondent's decision to remove the applicant as the president of the third respondent and party leader of the third respondent is declared ultra-vires. Well, my learned friend, Ms. May, has demonstrated that for starters, there's no reviewable decision. But for my purposes, as the person arguing the merits, let's assume that the so-called, so when I do this every time I say decision, it is to indicate that actually there isn't a decision. There's a litany of cases which show that when you do a so-called clerical exercise, it's not a decision in the admin law sense, paja, whether paja or legality. It's not a decision. But as I say, for my purposes, for now, we assume that there was a reviewable decision. But on what basis is it being reviewed? On the basis of ultra-vires. Now, that is either a complete misunderstanding of what ultra-vires means or something else, or there's no cause of action. Ultra-vires is just fancy Latin, which means that it's outside of the powers. Ultra, outside. Vires, powers, outside of your authority. In other words, what they are saying is that the IEC acted outside of its powers when it responded to the instruction from the letter. Now, there's nothing that could be further from the truth. You could say the IEC exercises powers improperly and so on, but you can't say it didn't have the powers. Regulation 9, which he read, says exactly that the IEC does have the power. if it's instructed by the party leader, with which we will go into now. So this case has got nothing to do with ultra-virus. It's just badly pleaded. But let's take it from as it comes. So that's the first point. If you get that aside, then we don't even have to go any further. And then, of course, paragraph 3, prayer 3 is even worse. My learned friend, Ms. May, tackled it from the point of view of jurisdiction. But on the merits, we have to look at it from the point of view of actually what it purports to do. What it purports to do is to be a substitution order. In other words, if you do review and set aside the so-called decision, then what they're saying is that you must not refer it back to the IEC. You, as the court, must now reinstate and override the IEC or exercise the powers of the IEC. Now, that's not done. Everyone knows that. The IEC is a specialist body which has the powers to do all these things. The court is not such a specialist body. And the court only does substitution under so-called exceptional circumstances. When A, the decision would be a fait accompli, B, there is bias on the part of the decision maker, and the case, which is well known, I'm not even going to bother the court, is called the Trencon. The Trencon case gives us the requirements for substitution. I'll get the citation. It's a 2015, I think 2015-5 decision of the Constitutional Court. Sorry, if you just bear with me. Yeah, it's 2015, volume 5, SA, page 245, CC, Constitutional Court decision. The judgment of Her Ladyship Justice Khampepe. Sorry, just a minute. And it lists the following factors. A, the court is well qualified as the original authority to make the decision. B, the end result is a foregone conclusion. C, further delay would cause unjustifiable prejudice. And D, the original decision maker has exhibited bias or incompetence. Now, none of that.
Where were you reading from?
From the Hoekstra.
Oh.
On admin law. It's page Hoekstra Administrative Law in South Africa, the 3rd edition, my lady. And the requirements are listed from page 790, the latest edition. Now, so this court is now being asked to do a substitution without any of those requirements being pleaded. No allegation in that regard. So apart from the issue of jurisdiction, even if we assume generously that the decision is reviewable and can be set aside, this court cannot reinstate Mr. Khumalo. And that is because, and again, I'll revert to that I don't waste time, to Ms. May's submissions for a different purpose. That is because Mr. Khumalo and his team are missing the most crucial point. Again, this is a manifestation of the so-called eau de Kral rule. You cannot come to this court to say that the leadership dispute must be resolved in my favor, and therefore all these things then we'll review and set aside. In other words, until this is what is called a collateral challenge. So until the decision to remove him as a leader is reversed, you can't move. Because the decision to remove him, according to the case of February that my learned friend read, is the so-called factional dispute, leadership dispute, and so on. That dispute belongs to section 20, bracket 2, big A. And you can do two things with a decision like that. You either come to this court in terms of 20, bracket 2A, or you go to the High Court on the basis of the common law, contractual, the usual political party disputes. So if you're going to come under section 19, or if you're basing your cause of action purely under section 19, you can come here. So it's the so-called concurrent jurisdiction. But if you are basing your case under the common law, the contractual relationship that was set out in Ramakatsa, then you can go to the High Court. It's simple, it just depends on how you plead it. Just like a labor matter. If you are going to rely on the LRA, you go to the labor court. But if your dispute is a contractual one between you and the employer, then of course you can come here. That's all. So they haven't done either one of those. So that decision must be regarded as valid until it's set aside by a competent court of law. And we know all the philosophical reasons for that. It's for certainty. The law would be chaotic, so to speak, if it didn't work like that. Madlanga J summarized the position as follows in the case of magnificent mile trading, which is, 2020, bracket 4 SA 375 CC. At paragraph 50. It says, the Odecral rule is itself informed by the rule of law. Imagine the specter of organs of state and private persons ignoring or giving heed to administrative action based on their view of its validity. The administrative and legal chaos that would ensue from that state of affairs is unthinkable. Indeed, chaos and not the law would rule. Because really what you would then be doing is you'd be bringing two cases before the court in disguise. Because you have to say, first you must find that the expulsion was unlawful, I don't know on what basis, and then moving from that, you must then deal with the case that is before you. You can't do that. So that's just the legal confusion that underlies this application. And so just on the, what you call it, the so-called review grounds, A, ultra vires doesn't apply, B, there's no case for substitution, and C, it's a collateral challenge which should have, at the very least, have been brought under, which has been brought under the wrong section, so to speak. So then let's go to the meat of the case on the merits, assuming that there is a reviewable decision before you. Now here, we are dealing with nothing else but criminality. If anything, tongue-in-cheek, that I would say, what Ms. May did not say is that the court doesn't have jurisdiction. It's because the matter should be in the criminal court. Because what we have is pure perjury by any definition. Among other criminal charges, I will show you that there are at least 2 counts of perjury. Maybe 3, maybe more, but at least 2 that I will point you to. Snyman defines perjury as follows. The elements of the crime are the following. Page 343. That's the 5th edition. The elements of the crime of perjury are A, the making of a declaration, B, which is false, C, under oath or in the form of equivalent to an oath, D, in the course of a judicial proceeding, and E, unlawfulness, F, intention. And that crime is punishable by imprisonment. So, Mr. Khumalo's big thing here is that, to summarize it, and my learned friend, to his credit, put this correctly. There are two versions. Let's forget even about Plascon Evans for now. One is that Mr. Khumalo wrote one letter to the IEC, according to him, and the other one was forged. Or Mr. Khumalo wrote, signed, and sent 2 letters. And I put the emphasis on signed purposely. Because the first theory, the forgery theory, is based on the one-letter theory. And our version is based on the fact that he wrote 2 letters. Not only did he write 2 letters, but the IEC has confirmed in this affidavit that it in fact received 2 letters and acted on them. And we'll explain why the 2 letters are important. But in the course of doing that, Mr. Khumalo, who not only faces now charges of perjury, but will also have to go to the civil courts for the defamation of at least Ms. Zuma Sambudla, who had been defamed. It started warmly by saying she sent the letter and she may be aware of a person who forged it. But now, as you read the papers, it's now she forged. And today it was very clear. Ms. Sambudla not only signed the letter, she also sent it. So let's start with the first count of perjury. At page 11, paragraph 28. This is what Mr. Khumalo says. That the statement about his expulsion, he says, purports that the decision to expel me and other executive members was taken by the National Leadership Corps, he says, sometimes referred to as the Interim Leadership Corps. And then he says, it is unclear to me where this structure derives its power in terms of the AKP constitution. Let's just pause there. Page. So it's unclear to Mr. Khumalo where the structure called the National Leadership Corps or the Interim Leadership Corps gets its powers. Then go to page 148.
$148.
148, by the way. This is a letter written by Mr. Khumalo on the 27th of February 2024, signed by him. He doesn't claim that this one is forged. And he says, the purpose of this letter, dear sir, is to the IEC. Dear sir, the purpose of this letter is to inform you that the MK party has resolved to hold its elective conference at all levels only after the 2024 elections. Until then, the party will be governed and led by an interim leadership corps appointed as such. So let's just pause there. So the structure that he says he doesn't know where it gets its powers, he explains to the IEC under his own handwriting that is the structure that is going to take us until after the elections. Then he says at page 14, this is the second count of perjury. He says, I wish to state that Ms. Zuma Sambudla excuse me, is not part of the leadership collective of the MKP, and therefore she is not authorized to communicate anything regarding the MKP with the IEC or any stakeholders on behalf of the MKP. He says this. At the end, he says, so help me God. And then, let's go back to page 148. At page 148, he says, in his own handwriting, which he has not disputed, paragraph 2, in line with the above, the MKP, via its ILC, that's the leadership corps, resolved on 19 February 2024 to make the following amendments in respect of the particulars furnished in its deed of foundation previously submitted in terms of Section 15 of the Electoral Commission Act 51 of 1996. Next paragraph. By the addition of the following names of the members constituting the executive body of the party. 1, Mr. Tandukolo Jodo. 2, Mr. Edward Njingila. And surprise, surprise, 3, Duduzile Zuma Sambudla. Signed, J.S. Khumalo, at page 149. So this is the same person that says she's not part of, swearing to God, she's not part of the leadership collective of the MKP, and therefore she's not authorized to communicate anything regarding the MKP. Then, as if that's not enough, let's go to page 150. This is a letter signed by Mr. J.S. Khumalo, now on the 19th of March 2024. It says, the purpose of this letter is to inform you that the MK Party's leadership has resolved that the login credentials for the IEC portal be changed and replaced as in paragraph 2 below. And then in paragraph 2, it says, in line with the above, the MK Party, via its interim leadership corps, requests that the following members' details be included. And the person, Duduzile Zuma Sambudla, and signed J.S. Khumalo, party leader. Now, I said there will be 3 counts at least. The most serious one, which goes to the core of why we are here, is the following. Let me paraphrase. My learned friend says that to this court, 1, Mr. Khumalo only wrote 1 letter. 2, when we are talking about JK, the JK 6 and 7, that's between JK and 6 and 7. In other words, he wrote JK6, I think, is the forged one. Yeah, allegedly forged one. And then JK7 is the genuine one. So he says, no, of those two letters, he wrote only one. Then he also says that Mr. Khumalo, remember the IEC says that Mr. Khumalo was literally harassing them with emails and phone calls to say, please, I've told you, you must replace me with Mr. Zuma, or all these things. So he says, no, that's not true. And then the third thing that my learned friend says is that, no, whenever he says Mr. Zuma is the president, he's just talking about his previous job, because he was the president of the country. Now you'll see from what Mr. Khumalo said, he says at paragraph 19, page 142, and I want to read. It's a pity, I had hoped to arrange for a screen in this court so that we could actually play the video, but because of the urgency, we couldn't do that. It's a very short clip. So this is what he says, quote, "So people must not tell lies. Namalala," that's Mr. Zuma, "is our president. I want to start with what is running on social media. There is something we have done. I want to explain this to avoid confusion. On the 12th, the ballot paper of South Africa indicating who will represent Umkhonto weSizwe was supposed to be issued. You will remember that I am the one who registered as the party leader of Umkhonto weSizwe. But we agreed that our president will be Nxamalala. We have never had a different decision. Because we have agreed that we would deal with this matter in this way, the time has come, not something about the old presidency, the time has come where we have to state publicly that Mr. Zuma is the one who will lead us as president." Then there's cheering. Now here's the important part, where he now creates the causal link. He says, that is why, those are important words, that is why on a previous Friday, I wrote a letter to the IEC to say that Mr. Zuma is the one who will be on the ballot paper to be next to our logo of the MK party. In other words, he's the one who's going to be our president, and people must not be confused. And that is why I, Jabulani Khumalo, wrote a letter to the IEC. And then he says, I wrote this letter because MK is not divided. We know what our mandate is and what we want. In that regard, the IEC disputed that I had written the letter myself. In other words, so the IEC now is being accused of also suspecting forgery or something. And he says, on the Saturday, the IEC asked me to send another letter which explains the same thing. They still doubted. On the Monday, I now decided to phone them, this time to ask why the ballot paper does not show the face of Mr. Zuma next to our logo. They said I had not told them. And listen to this. I said there are two letters. This is now the person who comes here to say there's one letter. I said there are two letters. What is it that you do not understand? They assisted us because they then did put him on the ballot paper. We have now seen that it has been printed and Mr. Zuma's face is next to our logo. More cheering. Now, for a person to then come under oath before a court of law and say that I only know of one letter, when I say president, I'm referring to the previous presidency of the country, And Mr. Siboto said that we must look at the context. Now, in the context of what he says here about which presidency he's talking about, it's very, very clear.
Mr.
But
Mpofu,
I'm sorry.
I need that link emailed
Yes.
to the registrar of the court, because we've got soft copies of documents in PDF
Yes.
format, so we've not been, certainly I've not viewed it. Because it's in
Been
PDF
able to play it,
format.
yes.
Yeah, so if it could please be, if you could ensure that the link is emailed.
Yes, we will.
To the
In
Secretary
fact,
of
not just
Elections.
we'll do the link and also even the video itself. Yes. And the
link don't burden the server. The link should suffice.
It should suffice.
Yeah.
Yes. Okay, because
And Mr. Mpofu, if you could state in the email the time stamp of where the two letters are mentioned.
of what the time. Yes. I'll say. Let me say something about that. The time span seems to be a bit confused, but that's fine. But the issue that I was emphasizing is the fact that in his own mouth, he said that he sent 2 letters, and he was actually angry, quote unquote, that the IEC did not, that the IEC but will send.
What I want is
extract here
on
the
that
statement.
video,
Yes.
like 1 minute, 23
Yeah.
seconds or something, he says about 2
Yes, absolutely. No. We'll do that. We'll do that. But the important thing here is that the video is well, in terms of Plascon Evans, it's in the answering affidavit, so therefore that's our version. But notably, even in the so belated replying affidavit, they steer away from it. Nobody says, no, you misunderstood it, and what have you, or the time span, or this, and so on. They don't even come anywhere near dealing with it. So on Plascon Evans alone, it has to be taken as having happened. If anything, at paragraph 8 of their heads, they actually refer to it. They say, well, when he made the statement, he was talking about the presidency, this thing that we had this morning. So, which means it's what we call confession and avoidance. So they accept that the speech was made, but they try to contextualize it. So there's no denial. Not even a bare denial. So where does that then bring us? It says that just for good measure, to make it easy for the NPA, I think that let me just refer to what I would call the 4th count of perjury. It says, I deny the allegation, at paragraph 143, I deny these allegations and particularly the false version of the alleged, this is what Ms. Zuma Sambudla says. And we're told that she hasn't denied them. I deny these allegations, and a particularly false version of the alleged forgery of the applicant's signature by Ms. Zuma Sambudla, who has informed me that. And Mr. Kasboto said that the attorney doesn't say that he was informed by Ms. Zuma Sambudla, which is false, because he did. And there's a confirmatory affidavit. So to the extent that one could say that it could have said that it's hearsay, her confirmatory affidavit is at page 155. That's an affidavit signed by Tuduzile Zuma Sambudla. It goes up to page 156. Now, not only does she deny this, she actually tells the court, because again, if she just said, well, I deny, we could have criticized in terms of Plascon Evans as just giving a bad denial. You know, in the face of such an allegation, if you just gave a bad denial, one could say, well, you know. But she says at page 144, The letter was indeed signed by the applicant during a meeting and in the presence of at least 2 other eyewitnesses, in addition to her. In other words, minimum of 3. All of whom were members or leaders of the party. The 2 are Mr. Farai Macha and Mr. Beki Manzini. And of course, Ms. Zuma Sambutla herself. And then the confirmatory affidavit of those people, you'll find at page 159 to 160 is the confirmatory affidavit of Mr. Beki Manzini, who was present when Mr. Khumalo was signing the document, the allegedly forged document. Page 161, you'll find the confirmatory affidavit, and due to the agency, we didn't add this name, but at least we said the minimum, so there's someone else. Of Mr. Raymond Khumalo is Mr. Jabulani Khumalo's brother. So his own brother has given us an affidavit to say he witnessed the signing of the document. And then, of course, Mr. Manzini, yes, and then Mr.
Mr. Mpofu, he just confirms the contents as far as they relate to him, and they don't relate to him.
Yes, but that's what I just said. Because of the agency in the list, what I said was that a minimum of 2 people, and listed those 2. That's why I started by qualifying it, that his name is not there. But the point of the matter is that he doesn't make it 1. Forget about all the 1,000 people who were there. There's an eyewitness, at least 1 or 2 or 3 or 4 or 5. It doesn't matter the number. But there are eyewitnesses who say to this court that we were there when the document was signed. That's all. Make it 1 or 2 or 3. It doesn't make it bigger or smaller. It doesn't matter what the number of eyewitnesses. But the word at least those people means that they were not the only ones. All right. So what do we have here? We have now, frontally now, this alleged allegation of forgery being refuted with credible evidence, corroborated evidence by the alleged forger and at least 1 other eyewitness. But as we say, we look at, when we do these things, we look at context. My learned friend, Mr. Sboto, I'll stop now at the 4 counts of perjury, but there's more. Mr. Kasboto asks what he regards as a rhetorical question. He says, why would Mr. Khumalo, having written the 1 letter, write another one? Well, there are 2 answers, and those answers, we're grateful to the IEC. I think we must say that publicly, because they get attacked so many times, that they have given the context of these exchanges. And I'll paraphrase to save time. What the IEC says is effectively the following. That, yes, Mr. Khumalo wrote a letter saying that he's withdrawing only as a party lead. Only as the face of the MK party on the logo, but not as party leader, something like that. Or at least it showed only that, to his credit. And yes, the exchange then happened. But here's the issue. The IEC says it was explained to him that the policy of the IEC is that the 2 things cannot be separated. Right? This is crucial. So the IEC says to them, even if that is your wish, it's not possible. So you can't have somebody who's going to be the so-called face on the ballot paper, but not the party leader. Now, that policy might be good or bad or indifferent, but nobody has attacked it in this court as irrational or whatever. So the policy is the policy. And you'll find that at page 108. It says the commission, that's the IEC, adopted a policy decision that only the registered leader of a party must appear on the ballot for that party. In order for Mr. Zuma to appear on the ballot as the party wished, he would have to be registered as a party leader. It's very clear. So if Mr. Khumalo did not like that policy, then he should have said this policy is against Section 19 of the Constitution or whatever, and taken the policy to court. Having failed to do that, he must be assumed to have accepted the policy. So that's the first reason, and I'll come back to it. The second reason why he wrote the second letter will be found at page 110. It started at 109. This is the letter from the IEC, from Mr. Apane. It's an email. So at 7:02 on the 9th of April, Mr. Apane of the IEC sends a further email to Mr. Khumalo on my instruction, that is on the instruction of Mr. Shiburi, the Deputy CEO of the IEC. And they literally give them almost a manual. So they say, submit a request to change the party leader so that the preferred candidate's face appears next to the MKP ballot. That's at number 2. I'll jump the other ballot, but number 5, also important. Well, number 4 is important on the 2-letter theory. It says, a letter was received. In other words, that would be the first letter, the unforged letter. But its contents were requesting that the face of the former president be on the ballot. So we assume that's the letter that's not controversial. And then they say, I advise that the only way to have former President Zuma next to the MK party was to have your details changed as the party leader to that of former President Zuma. When it says your, it means Mr. Khumalo, because the letter is addressed to him. You, Mr. Jabulani Khumalo, called Kim Kresfelder today, and I joined Kim in her office wherein you indicated that you don't want to be changed as the party leader. That's what Mr. Siboto was saying. I requested that you indicate in writing confirmation that I suppose you don't want to be changed to be as a party leader. When no written communication came forth, I approached the manager, whatever his name is. You have still, as at 7:02, you have still not changed the party leader and have not submitted the current party leader's photo. And then here's number 10, which is the answer to Mr. Siboto's question. The MK party's name will not have a party leader on the ballot if you cannot remedy this situation by today, 9th April 2024. In other words, the deadline, it's 7 o'clock. That means you have a couple of hours to remedy the situation. That's the answer. And that is why at 8:30, 2029, later that evening, says the IEC. Oh, I'm sorry, I must not jump paragraph 22. It says a copy of the email chain is attached to as WRS2. That's the email sent to Mr. Khumalo containing that manual, which he has not denied. There were also numerous telephonic discussions concerning the issue as appears from the emails. In other words, Mr. Khumalo, after that, was interacting with the IEC. And here comes the so-called forged letter. Later that evening, at 2029, Ms. Zuma Sambutla addressed an email to the Commission. In this email, she attached a letter dated 9 April 2024, in which Mr. Khumalo apparently communicated his resignation as party leader and Mr. Zuma's appointment. A copy is attached as WRS3, which is the same as JK6. the so-called forged letter. So that's all that happened. Mr. Khumalo was putting pressure on the IEC, and they made it clear what the policy says, that the two things go together. You can't have one and not the other. And then they gave him a deadline to rectify the situation. And the situation was rectified at 2029. Now, here's the rhetorical question. How would Ms. Zuma Sambudla have known about this communication between Mr. Khumalo and the IEC by email, by phone, and the deadline, and so on? If she was sitting somewhere else and she just imagined that at 8:30 I must just forge a letter and send it to the IEC without anyone asking for it, without any exhortation, without knowing about the telephone calls, without knowing about the emails. So it's obvious that Ms. Zuma Sambutla's version is correct, that all this was being done when they were presumably in the same place with the two eyewitnesses, and then they received they were receiving all this correspondence and phone calls and so on, and then the letter was signed in front of everybody, and it was sent in front of everybody. And that answers Mr. Kasiboto's second question. Why was Mr. Khumalo not copied in the email? Because he was there. He was in the room. And they were, why would he be copied when he's there? He's the one who gave the letter to Ms. Zuma Sambudla to email in front of people, including his relatives. So that's really the long and short of it. So unless we can be shown that the IEC is making up this story, that it repeatedly, I think is the word they use, explained both to Ms. Zuma Sambudla and Mr. Khumalo that you can't delink the face of the party from the party leader. And that the IEC is also making up the fact that it then gave the deadline, and it's also making up the telephone discussions between Mr. Khumalo and all these people. Oh yes, at 24 it says, against the backdrop where Mr. Khumalo had requested repeatedly for Mr. Zuma to be the party's face on the ballot, the Commission had no reason to doubt the veracity of the letter whatsoever. And well, there was no reason to doubt the veracity. So what do we have here? We have a person. No, let me make this point so that the picture is clearer for the court. Remember, all this is supposed to be happening on the 9th of April, and then the Commission on the 10th. The Commission confirms at page 87 that on the 10th it then did the changes as indicated. And my learned friend, when she was talking about the issue of urgency, she then says, well, there's no explanation as to why we suddenly get the application in May, on the 16th of May. That is because of another deceptive facility that is used. This one is not as clear-cut perjury as the others. It is because Mr. Khumalo does not tell this court when it is that what you call the leadership squabble or the fallout actually happened. The reality is this. He did all these things on the 9th. He sent the 2 letters. There was a change of the face, as he says in the thing with the cheering. Then it was resolved, and so on, and then we were all happy. That's the 9th. Then the following week is the 16th. And then on the 23rd, 2 weeks later, is when he was, according to him, expelled. So all was well for all that time. And that's why in his affidavit he doesn't tell you when the expulsion happened. Because he wants this court to believe that these things happened against each other. You know, there was this forgery, then he was expelled, and then all this is part of getting rid of him and so on. So you have to read the papers very carefully to find the date of his expulsion. And you'll find it at page 66. This is the letter that Mr. Khumalo writes to the IEC on the 5th of May. He says a whole lot of things which I don't want to bother the court about. But somewhere in that letter, hidden at paragraph 8, find the date of his so-called expulsion. It says, on 23 April 2024, I was called into a meeting with several individuals who are not in the National Executive Committee, but who have been active in the MKP. Mr. Zuma announced that I had been removed as president of the party and that he would henceforth become the president. Forget that, that's a new version. Now, remember, the other version was that he just said, Nyakosha. Now, so let's forget that. But now he says he was being removed as president and he would henceforth. Somewhere in his affidavit he says, I was being removed as the president and a member. But let's forget all that. That will be resolved in the criminal courts. But the point I simply want to make is that we then find the date there, that's the 23rd. In other words, all the other 2 weeks was all very well until he gets expelled. And then he starts with his campaign of lies. So that explains, because even myself, I was not able to make this connection until I found this date, as to why did he just sit and do nothing and actually celebrate, according to the clip, the replacement of Mr. Zuma as the party leader. So it's very simple. What happens is that Mr. Khumalo, like all of us, knew that the draw card for the election is the face of former President Zuma on the ballot. And we know how that has turned out. And like all of us, he knew that the logo, next to the logo is Mr. Zuma's face and not his face, then the election result would be favorable to the party. Knowing that, he was also informed by the IEC about what I call the symbiotic relationship between in other words, the price to pay for having former President Zuma's face on the ballot and getting millions and millions of votes is that he should resign as the party leader. And any pragmatic person would do what he exactly did, which was then to write the letter just before the deadline and give it to Ms. Zuma Sambudla and have it sent in front of everyone to the IEC. I'm quite sure if the IEC had said, we want this letter by the 12th of April, then the letter would have been sent on that day. But they said we want it today, 9 o'clock. They said that at 7 o'clock. So once the now disgruntled Mr. Khumalo, after his expulsion, which is not before this court, if he wants to fight that expulsion, he must go elsewhere. But once he was disgruntled about his expulsions, whether it's lawful or unlawful or whatever, is another matter. But once that happened, he then adopted this vindictive stance, which is fine. I would feel bitter myself if I was in his position. But what he's not allowed to do is to lie under oath in the process, because that is a crime. All of us would have been aggrieved, all of us would have maybe gone to court or not gone to court or whatever, or call those people who did that to you names. That's fine, that's human. But the line must be drawn at actually coming and having all of us sitting here on the basis of a pack of lies, demonstrable lies that he has concocted to I don't know to what end. So that's really the legal issue, because it goes to why his claim must be dismissed, as my learned friend said, but also it goes to the sheer abuse of the court process to an extent that one has never even seen. You know, this court previously found that Mr. Zuma had abused the court process. And let me tell you what the story was. It was because he had instituted private prosecution on a particular date, which happened to coincide with some political conference in Nazareth.
It was a different court. We just happened to be sitting in the same building.
Oh, yes, of course. It was this room. It was in this room, yeah.
And
but I take the point, yes.
I happened to have been part of that panel.
Yes,
it's just a coincidence. I was on that panel.
You know, that part, I'm not going there. But it was in this room, but you're quite right, Malik. It was the Johannesburg High Court, the full court at that. But just as a point of reference, I'm saying Mr. Zuma had received a letter from the NPA, I think at the end of November, and then 2 weeks later he instituted proceedings. And then because that date, which was 2 weeks later, happened to be the first day of the Nazareth conference, it was found that he did that to coincide with that conference so that the step-aside rule and all sorts of things like that should be triggered and so on. And on that basis, so on that basis, if you compare that to what I've just outlined to you, which is a clear, deliberate campaign to lie and to make up non-existent facts and not to respond to the counterfacts. To that situation where Mr. Zuma had actually said, no, this was a pure coincidence, and indeed I wanted to just do this before the holidays start so that it's all done, like all lawyers do, and it's out of the way. But here there's no version to explain these lies. And so on that basis, when the shoe is now on the other foot, surely the findings of abuse of process are warranted. Sorry, I just want to give the court some references. The famous court case of Beinash versus Wixley, which is the locus classicus on abuse of court process. 1997, bracket 3, SA 721, SCA at 313. It says the High Court has inherent jurisdiction to protect, and I suggest any court, to protect itself from abuse of its process. And then at page 734, G to H, this is what the court said. Abuse of court occurs, quote, where the procedures permitted by the rules of the court to facilitate the pursuit of the truth are used for a purpose extraneous to that object. And more than 100 years ago, well, yes, well, no, almost. In 1927, in SCJ, in Hudson versus Hudson, which was 1927 AD to 259 at 268, said, abuse of process happens where, quote, an attempt is made to use for an ulterior purpose the machinery designed for the administration of justice. So this court, unlike the criminal court, cannot impose any criminal sanctions, but it can certainly punish the abuse of its own process by a punitive cost order and hopefully also words that will show its displeasure at being abused, I mean, in the most extreme manner that I've ever witnessed. And the connection between that and the scale, of course, will be found in the case of Public Protector versus South African Reserve Bank. The Constitutional Court said the following, and that's 2019 bracket 6, SA 253, CC. The court said more than 100 years ago, NSCJ stated the principle that courts on the attorney and client scale are recovered when a court wishes to make its disapproval for the conduct of a litigant. Over the years, courts have granted costs on the attorney and client scale to mark their disapproval of the fraudulent, dishonest, or malafides conduct, vexatious conduct, and conduct that amounts to abuse of the process of the court. Sorry. We'll find the paragraph just. But that's in the 2019-6 SA 253 CC. So let's then very quickly go to the two letters, page 62 and 63. We start with the admitted letter or the genuine letter. Now, you have to remember that this is now a Mr. Khumalo who sends the first letter. He says, this serves to confirm that in my capacity as the President of Congress, I hereby direct and authorize the Independent Electoral Commission to place in the final ballot paper next to MK Party logo and or brand, this must be a typo, the face of President Jacob Zuma be printed in the final ballot print. I hereby confirm that President Jacob Zuma is appointed to be the MK Party's presidential candidate for the 29th May national provincial elections. Now, there it's clear that it's not the context of the speech. Here is talking about the presidential candidate. Then hope you find the above in order, what have you. So that's the first letter according to the IEC, which they then write back to say it's not adequate. Please send us another letter by 9 o'clock. And then comes the second letter, where he now has to be explicit. He says, I hereby tender my resignation as party leader and request to be replaced by President Jacob Zuma. Also, I would like to take the liberty of informing you that a motion which stems from the National Leadership Corps, the one that he says he doesn't know, meeting where a decision was taken and concluded that President Jacob Zuma and that a letter be written to the IEC for the final and only inclusion of Mr. Jacob Zuma's face to be on the ballot paper as the recognized face and leader of the MK Party, face and leader of the MK Party for the 29 May 2029 national election. Based on the above, we that means the MK Party now, or the leadership, we therefore request that in the face of President Zuma be in the final printed ballot paper next to the Mkhonto weSizwe logo and brand. This is now, he writes this letter now at the time when he's now been armed with the symbiosis theory, that the two have to go together. And that's why he's correcting to meet the deadline that has been communicated to him. That paragraph in the public protector matter is paragraph 8. Thank you. Sorry. Sorry, I want to the last thing I want to do is just to refer to the IEC. I'm sure Mr. De Beer will deal with it, but just to emphasize the issue of the sequence of events from their point of view, because this is very interesting. Obviously, the people from that I represent have the version of what was happening from their side, where the meeting was taking place. But fortunately, the court is in a better position because it's also given the mirror. It's like a movie. You now get given what was happening on the IEC side at the same time. So they write to them, and then after they write what happens, then there's an email, then there are phone calls, and then these ones respond and so on. So you almost have a split screen of what was happening in the evening of the 9th of April. Sorry, it's just, yes. Paragraph 109 in particular, where Ms. Kressfelder now puts it clear to Mr. Khumalo, and it's put in quotes, I think, for a reason, because it's probably a verbatim. It says, "Will you kindly send us a letter to change the party leader, or are you not going to?" That's what was said before the earlier exchange that I had. That I had referred to. And at paragraph 9, just for cross-referencing, let's start at paragraph 8, 105 and page 105, sorry, paragraph 8 and 9. Paragraph 8 covers what Ms. May, my learned friend Ms. May, spoke about. Up front, I must emphasize that the Commission denies taking any unlawful decision. The Commission amended its records to reflect a change in the party leadership in the MK party after it received a letter from Mr. Khumalo as the party leader. Commission has also no power in law to determine who the party leader of a party is. And then it says in paragraph 9, as I explained below, the letter was received late. The letter was received late in the evening of 9 April 2024, after lengthy exchanges of emails between Mr. Khumalo and the Commission. Lengthy exchanges of emails between Mr. Khumalo and the Commission concerning the circumstances in which Mr. Zuma could appear as the face of the party on the ballot, as Mr. Khumalo and the party wished. The Commission explained that the registered leader of the party is the person who is to appear on the ballot. So that's the context, including where they explain the so-called policy. But yes, if you talk about, as if there's any need to take the matter any further, Mr. Khumalo then tells us that after the 23rd of April, obviously, he says he then suspended former President Zuma. Now, somewhere in his papers, he also says former President Zuma was never a member of the MK party. So he was suspending him from what? And this is the kind of thing that really gets presented to this court. And again, if you follow that train, which we were not going to do, that train of thought, then it's clear that this was obviously after the fallout. These are issues which may or may not be resolved if they ever bring the correct application under Section 22A, big A, which is really what he should have done. And then, of course, he says that one of his grievances, and I don't know if Mr. De Beer will address that, one of his grievances is now that when he then presumably changed his mind, he wrote the letter to the IEC to say that the IEC must remove Mr. Zuma as the party leader and put him. But the IEC, now, and that goes to what my learned friend was saying. If the IEC had done that, which is presumably what has brought us here, because the IEC refused to comply with that letter of demand. If the IEC had done that, then it would have been breaching Regulation 9. Because why would the IEC remove Mr. Zuma, put Mr. Khumalo, based on a letter from a man in the taxi rank who's just who's not a member, who's not a party leader? Because remember, the very reason why Mr. Khumalo was being asked, exhorted, and so on, was because he was the only person in this whole country who, according to Regulation 9, who could write the letter to do the replacement. So similarly, the IEC could only respond to a letter which comes from former President Zuma, because he's now the registered party leader. So if he had written and said, I'm now asking for Mr. Ndlela to be the new person, or put vice versa, if Mr. Ndlela had written the letter, then it should be ignored as well and just thrown into the dustbin. So only if it came from the registered party leader. So all the other gymnastics that were being done after the fact really do not have any. Yes. Sorry, yes, we gave you I just knew that this paragraph was too early in that case. The correct paragraph in the public protector case is paragraph 223, not 8. Sorry. So we now know that Ms. Zuma Sambudla was, by the hand of Mr. Khumalo, the person who's supposed to be communicating with the IEC, but also was, despite his denial under oath, one of the persons that he had instructed should be inserted as a national leader. I don't even want to talk about the issue of the former president, because he says it very clearly in his speech as to the sequence of events, albeit that some of the dates might not tally with what we have. And since this case, by the way, is not about anything allegedly that Umkhonto Wesizwe, the third respondent, or former President Zuma, the fourth respondent, has done per se. They are alleged forgeries and all sorts of things brought in as evidence. The real case is the section 20 bracket 1A review of the IEC's decision. So we have to keep the eye on that ball. That it is that. Firstly, the IEC says, well, we didn't make a decision, let alone one that can be called ultra-virus. And therefore, the answer to the real case is found at paragraph 24, at page 1110. Against the backdrop where Mr. Khumalo had requested repeatedly for Mr. Zuma to be the party's face, the Commission had no reason to doubt the veracity of the letter whatsoever. The fact that it was emailed by Ms. Zuma Sambudla was of no concern to the Commission, since the request to have Mr. Zuma as the party's face had been made by Mr. Khumalo over the last few days, including in his letter attached to this affidavit as JK7. So one can simplify that what the IEC is saying as follows. What Regulation 9 requires is that you must have a letter signed by the leader. But Regulation 9 has never said the letter must also be emailed by the leader. It doesn't work like that. Imagine if there was a letter that says the minister must authorize this, or the chairperson of the board must authorize this. And then you come to court and say, no, but it was emailed by the company secretary. I mean, really? The point of the matter is that once the IEC received the letter signed under the hand of the principal, so to speak, the designated person, then the IEC is has to be satisfied. That it was emailed by so and so and what have you is really not, is neither here nor there. And that's why the IEC says in conclusion at paragraph 26, the Commission submits that it has acted lawfully and reasonably in the circumstances. End of the story. So unless if they can show that the Commission has acted unlawfully, unreasonably, irrationally, all the adjectives that we know, or adverbs that we know, then that's the end of at least the section 20 bracket 1 bracket A case. Let alone what my learned friend Ms. May has said, that section 21B then says that it must be conducted urgently. So the issue of urgency here is not just the normal Rule 612. It's a statutory obligation. It shall be conducted urgently. And then it says, and the decision must be given expeditiously. So the second part you can ignore. That's for the court to decide expeditiously. But the first part that says it shall be conducted expeditiously, urgently, is an obligation of the applicant, a statutory obligation of the applicant. And this court confirmed this in the case in Bloemfontein. Fortunately, 2 of the justices were in that court. This court confirmed this in the case of the ANC versus IEC and MK party in March, on the 19th of March, that the urgency is not solely, it's a statutory obligation, peremptory provision of the Act. Even if you cut it aside from the Rule 6, the non-compliance with Rule 6, which is an issue of condonation. That's where these issues always, they can be conflated. The urgency is the statutory requirement, and then the non-compliance with the rules is the one that.
Kuyaqhubeka nokuqulwa kwecala elifakwe nguJabulani Khumalo owabhalisa iqembu le-MK ethunywa nguZuma.